India Legal presents Court This Week.
Hello and welcome to Courts This Week. I am Tanya Chug. In this special edition, we bring you top stories of legal proceedings from the courts, from lower and subordinate courts to high courts and the Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you on all important proceedings. So let's begin Courts This Week.
India Legal presents Court This Week.
The Supreme Court has stayed the contempt proceedings which were sought to be initiated against Maharashtra Governor Bhagat Singh Koshyari by the Uttarakhand High Court, which had issued notice on the same, the contempt proceedings system from the alleged failure of the governor to follow an order of payment of market rent for a government bungalow which was allocated to him in his capacity as a chief minister.
The Supreme Court has stayed the contempt of court notice sent by Uttarakhand High Court to Maharashtra Governor Bhagat Singh Koshyari for not paying the market rent for a government bungalow allotted to him when he was Chief Minister of the state. The bench of Justices Rohinton, Nariman, K.M. Joseph and Krishna Murari issued notice to the state of Uttarakhand and tagged the petition with a pending plea challenging the basis at which the market rent rates were ascertained by the High Court. In his plea, Koshyari has stated that since he is the sitting governor of Maharashtra, the bar under Article 361 of the Constitution cannot be ignored while issuing notice and plea seeking contempt action against him. Article 361 affords protection to the President of India and governors of states against legal action before courts. By way of background, in June 2020, the Uttarakhand High Court struck down a law brought by the state government to validate the preoccupation of state provided bungalows by former chief ministers and the illegal expenditure incurred on that account for over a 19-year period. At the time, the court had also directed that the former chief minister pay market rent for the term of their legal occupation over a 19-year period. A review petition filed against the verdict was dismissed by the High Court on August 7, 2019. In his SLP before the Supreme Court, Governor has contended that he was never a part of the process to determine market rent of the residential premises allotted to him. It is further contended that Koshyari was in occupation of the residential premises under an order issued by a lawful authority under a rule which was not in dispute at the time of allotment. Further, he had vacated the same as soon as he was required by law to do so. Bureau Report.
Supreme Court has allowed the central government to conduct the foundation ceremony of Central Vista project without altering the status of the site in any manner, after the court slammed the central government for going ahead with the construction on works of the project even when the judgment on the petitions against it is awaited. The Solicitor General Tushar Mehta undertook that no construction or demolition of structures or cutting down of trees will take place.
The Supreme Court clarified that the central government is free to go ahead with the foundation stone laying ceremony of the Central Vista redevelopment project on 10th December, but cannot carry out any construction or demolition at the project site till the top court pronounces its judgment in the petition challenging the project. An order to that effect was passed by a bench of Justices A.M. Khanwilkar, Dinesh Maheshwari and Sanjeev Khanna, after the central government, through Solicitor General Tushar Mehta, undertook that no construction, demolition or felling of trees will be carried out till the top court decides the case one way or the other. The clarification was made by the Apex Court after it listed the case for hearing suo motu taking exceptions to the government's plan to begin construction activities. The Central Vista area in Lutyens Delhi houses Iconic buildings like the Parliament House, Rashtrapati Bhavan, the North and South Block buildings and the India Gate. The petitioner before the Supreme Court have challenged a notification issued by the Delhi Development Authority DDA on 21st December 2019 regarding changes in land use for the redevelopment. In November, Solicitor General Tushar Mehta, representing the centre, had said that the current Parliament building, which was opened in 1927, does not adhere to fire safety norms, has a serious space crunch and is not earthquake-proof. The building was built in 1927 prior to independence and was intended to house the Legislative Council and not our bicameral legislature we have today. The building does not conform to fire safety norms and water and sewer lines are also haphazard, which is damaging the heritage nature of the building. Once there is an increase in the number of seats of the Lok Sabha and the Rajya Sabha after the fresh census to be conducted next year, the building will be under stress, Mehta added. He had also cited security concern, highlighting the 2001 Parliament attack. Bureau Report.
A highway project in Tamil Nadu that will cut travel time between Chennai and Salem city cleared a big hurdle today as the Supreme Court allowed the acquisition of farmland opposed by farmers along the planned route. The rupees 10,000 crore Chennai-Salem highway project had been held up by a Madras High Court order last year, which cancelled land acquisition. That order was challenged by the National Highways Authority before the Supreme Court, which has now overturned it.
The Supreme Court has upheld the notifications issued for acquiring land for the Chennai-Salem 8-lane Greenfield Expressway project, partly allowing the appeals of the Union of India and the National Highway Authorities of India. The top court reversed the Madras High Court judgment to the extent it quashed the land acquisition notifications. The court said that it has negativated the challenge against the notification issued under the National Highway Act. However, the top court has maintained the directions in paragraph 106 of the High Court judgment regarding the reversal of entries in the revenue records, which stood mutated following the acquisition notification. Fresh notification proceedings need to be issued with respect to the acquisition of those lands. A bench comprising Justices A.M. Khanvilkar, B.R. Gawai and Krishna Murari delivered the judgment in the appeals filed by the central government and the National Highway Authority of India or NHAI against the Madras High Court judgment which quashed the notification for acquisition of land for the highway project. On April 8, 2019, the Madras High Court quashed the acquisition proceedings for the 277-kilometer proposed highway passing through agricultural as well as reserve forest land. The prime issue in the case was whether prior environmental clearance was necessary before acquiring land for the highway project. A division bench of Justices T.S. Sivaganam and V. Bhavani Subarayo of the High Court held that the prior environmental clearance under the Environmental Protection Act 1986 was necessary before acquiring land invoking the powers under the National Highway Act. The bench rejected the argument advanced by Central, Tamil Nadu government and the National Highway Authority of India that environmental clearance was not needed at the time of securing the land for highway construction and that it was needed only at the time of actual laying of the road. The court termed this argument as putting the cart before the horse. The conclusion of the court was based on the fact that large tracts of agricultural lands and forest lands were proposed to be acquired for the project. The court said that the issue has to be approached applying the public trust doctrine as per which the state holds public land and resources at trust for benefit of people. The court put particular emphasis on the fact that the acquisition will impact large tracts of fertile farm lands. The court also noticed that the respondents had not disclosed the proposed plans for rehabilitation and resettlement of people who will get displaced. Bureau Report.
The Jammu and Kashmir High Court has made an important observation regarding terrorist activities in the state. It has said that Jammu and Kashmir is facing onslaught of terrorist activities from the neighboring country, which is orchestrated by ISI of Pakistan. Case relates to a person who was caught sending photographs of vital military installations to ISI.
While observing that Union territory of Jammu and Kashmir is facing onslaught of terrorist activities from the neighboring country, which is orchestrated by the ISI of Pakistan, the Jammu and Kashmir High Court denied bail to a person named Pankaj Sharma, who allegedly hobnobbed with ISI of Pakistan and passed on photographs of vital installations and troop movement to them. The bench of Justice Sanjay Dhar further observed, providing of vital information and photograph to the intelligence agency of an enemy country, to my mind, is nothing but waging war against the country. As per the prosecution's case, the petitioner Pankaj Sharma sent photographs of vital installations of Indian territory to ISI through Facebook Messenger, and in lieu thereof he received money, thereby posing danger to the security, integrity and sovereignty of the country. On the basis of this information, an FIR came to be registered and Sharma was taken into custody. The pictures were allegedly sent to two Facebook IDs who claimed that they were stationed at Sudan, which were later found to be fake. The money is stated to have been received by petitioner and his relatives and friends from Dubai, Maharashtra, etc. Thus, according to the respondents, offences under Section 121 IPC and Section 3 of the Enemy Agents Ordinances are made out against the petitioner. The senior counsel for the petitioner submitted before the court that mere taking of photographs of some installations and sending it to same persons stationed at Sudan would not amount to either hobnobbing with enemy agents or waging war against the government of India. On the other hand, the respondents argued that the petitioner knowingly indulged in activities which are prejudicial to the security of the state. Court also noted that there is a material on record to suggest that petitioner, his mother and his friend Ashwani Kumar were receiving money in their bank accounts in exchange of these photographs. The court further noted that co-accused in the case are yet to be arrested and interrogated. The investigating agency has submitted that after their arrest and interrogation, supplementary charge sheet will be produced before the court. Bureau Report.
The Supreme Court bench, headed by Justice Umesh Lalit, has remarked in an order while appreciating the presentation by a state counsel, Sumir Sodhi, who submitted convenience notes. The bench said that this is how a case can be presented on behalf of the state. Advocate Sumir Sodhi had appeared on behalf of state of Chhattisgarh in a criminal appeal preferred by the accused in a murder case. The court in its judgment reproduced a convenience note submitted by him, in which he briefly and succinctly described the details of FIR, accused persons, history of proceedings and also the legal submissions on behalf of the state.
Convenience note submitted by Chhattisgarh government's standing counsel Sumir Sodhi in murder case before the Supreme Court came in for special praise by the top court, which not only lauded the format of the note adopted by the lawyer but also suggested counsel for other states to follow the format. The three-judge bench headed by Justice U. Lalit cited the format of the note, stating that it was an illustration of how a case can be presented on behalf of the state. The bench also comprised Justice Vineet Saran and S. Ravindra Bhatt, directed that the copy of the order passed by the court in which the note was extracted in its entirety be circulated through standing counsels of all states in the Supreme Court. We must observe that the presentation made by Mr. Sumir Sodhi in the note extracted above is an illustration how a case can be presented on behalf of the state. We may suggest that the said note may be taken as the standard format by all learned counsel appearing for various state governments in the state. The registry may circulate copies of this order to all learned standing counsels for the state. The court said in its order. Advocate Sodhi in his convenience note had in a tabular format given details of FIR, accused person, history proceeding and also legal submissions on behalf of state. Sodhi appeared on the behalf of state along with Advocate Ridhima Juneja. The court, with the help of convenience note, came to the conclusion that the case of three appellants was on the same footing as that of the four other co-accused who were early acquitted, the case involving charges of murder under Section 302 of IPC and causing voluntary hurt. With the assistance of the learned counsel, we have gone through the record and are satisfied that the role attributed to the present appellants was not in any way different from that attributed to the other four acquitted accused, said the bench. The court therefore allowed the appeals and set aside the conviction and sentence handed down to the accused. Bureau Report.
The Delhi High Court on Friday stayed the operation of the order passed by the Central Information Commission, directing the Indian Air Force to divulge under the Right to Information Act information relating to Prime Minister Narendra Modi and former Prime Minister Dr. Manmohan Singh's entourage on foreign trips. The stay order passed in a petition filed by the Air Force challenging the CIC direction.
The Delhi High Court has stayed a Central Information Commission order directing the disclosure of information about the foreign visits undertaken by Prime Minister Narendra Modi and former Prime Minister Manmohan Singh. A single judge bench of Justice Naveen Chawla issued notice in the challenge preferred by Central Public Information Officer Directorate of Personal Services Air Headquarters, Indian Air Force, was the petitioner, and sought response from RTI applicant Commodore Lokesh Batra. Appearing through Advocate Rahul Sharma, the petitioner argued that while information on the number of flights visit had already been provided, the information sought by applicant with respect to the entourage was extremely sensitive in nature. Specifically opposing the disclosure of names and designation of persons and security personnel accompanying the Prime Minister, Sharma contended that the information had nothing good for the applicant. Sharma argued that information on Prime Minister's Special Protection Group was exempted from disclosure under Section 8 of the Right to Information Act. In view of CIC order, the court suggested the petitioner to disclose the number of persons who accompanied the Prime Minister and withhold details of persons occupying sensitive positions. The CIC sent the ball to your court to see what can be given. The court remarked, being identified information that could or could not be shared under Section 8 of the Act. Advocate Prasanna S. opposed the petition on the ground that it was misconceived and that the Chief Information Commission order was passed on the petitioner's undertaking. In its order, CIC directed the petitioner to provide certified copies of available and relevant flight records sought by the applicant after severing the names and other relevant identifying particulars of the security SPG personnel. The matter will be heard next in April 2021. Bureau Report.
A writ petition has been filed before the Allahabad High Court challenging the constitutional validity of the UP government's controversial ordinance against religious conversions in the name of love jihad. Advocate Saurabh Kumar has moved the High Court stating that the Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020 is both morally and constitutionally repugnant. He has urged the court to declare this law as ultra-vires the constitution and in the interim direct the authorities not to take any coercive action in pursuance thereof. The petitioner has submitted that the passing of the ordinance could satisfy the first condition of legality. However, the state action falters when it's come to test of need and proportionality. It is submitted that provisions give the state policing powers over a citizen's choice of life, partner or religion and thus militate against the fundamental rights to individual autonomy, privacy, human dignity and personal liberty guaranteed under Article 21 of the Constitution. Taking exception to this, the petitioner has submitted that the very concept of forcing an individual to explain and justify a decision which is closely personal to him or her before an officer of the state is contrary to constitutionalism. It may be noted that this ordinance, along with Uttarakhand's Freedom of Religion Act 2018, have already been challenged before the Supreme Court. The PIL prays that these laws made in the name of love jihad be declared null and void because they disturb the basic structure of the Constitution. That's all for Courts This Week today. Keep watching APN.
India Legal presents Court This Week.